Okay, so our next speaker is Professor Matthew Rimmer from here at QUT, in fact, who is a Professor of Intellectual Property and Innovation Law and the head of our research programme as well. So we're really delighted to have him and who's very, very supportive of all the work that we do in this space. But he's going to be talking today about some of his latest research around greenwashing in the trademark law and internet domain name space. So combining two of the things that I'm very passionate about, which is environmentalism and technology.
Thank you very much. Today I'm talking about greenwashing, trademark law, consumer law and internet domain names. I'm a Professor of Intellectual Property and Innovation Law. I used to be an ARC Future Fellow looking at intellectual property and climate change, and the work that I'm talking about today has really kind of evolved out of some of the empirical research I was doing over that phase. I have indeed gone down the rabbit hole and in some ways have become lost, as it were, in the torrent and surf of greenwashing that is out there. But I'm still kind of hopeful that I'll be able to bring together this body of work that I'm doing. We have about a dozen researchers as part of our group in terms of the IP and Innovation Law program. We cover a range of different themes, looking at trade, IP, media and communications law, innovation law and open licensing. As part of that, one of our kind of key areas of interest is democratising energy. So this talk in some ways picks up some of the key themes that are present in Professor Christopher Wright's book. He has a kind of a deep preoccupation with corporations engaging in greenwashing and astroturfing and climate denial. And I guess my work is kind of particularly interested in thinking about the role of law and lawyers in terms of responding to some of those challenges. And really also talking about some of the limits of the law as well. I mean, some of the issues that I come up against is that some of our existing regimes are not necessarily very well equipped to deal with some of those issues and some of those problems. To begin with, I'd like to also kind of think a little bit about climate fiction. Tim Winton has a nice book about Western Australia, and there's this beautiful passage at one point in which he kind of talks about the epidemic of greenwashing in Western Australia, particularly kind of promulgated by the mining industry. And he kind of talks about, you know, how civil society organisations couldn't compete with the huge advertising budgets and the madmen of these mining companies being able to pump out all this material saying that they were nature's great custodians. But in particular, he kind of talks about the notion of fakes, and as a kind of a defining theme of 20 years of doing research in relation to intellectual property, I've always been very kind of interested in fakes. So I guess my interest in greenwashing really kind of stems from an interest in how do you deal with fake material of one kind or another. In some ways, with the rise of Trump, the issue has become even more topical in an age of post-truth discussions about climate change, alternative facts, and allegations about hoaxes. All this kind of work has kind of taken on a particular new significance and importance. There's been quite a lot of work done in this area, and I've kind of done larger literary reviews which have looked at some of the issues in relation to greenwashing, as well as being a kind of a business issue and a marketing and advertising issue. It's raised larger legal and ethical questions, particularly in terms of the operation of consumer law. There can be action in relation to misleading and deceptive conduct. There's also codes of ethics in relation to advertising. So there's often been some really intense battles in relation to litigation. Naomi Oreskes and Eric Conway did a lot of work on merchants of doubt. There's been a lot of borrowing from the playbook of big tobacco in terms of some of the strategies that have been deployed in relation to some of the debates over fossil fuels and climate change. It's been very interesting as a researcher who's done work on both tobacco control and plain packaging and kind of greenwashing, that there's similar sorts of strategies in relation to the use of astroturfing and front groups, which I think amongst other things raise certain sorts of legal issues. And then there have also been kind of larger kind of concerns as well in relation to the problem of climate denial, which was also really discussed by Christopher Wright, both in terms of his book, but also in terms of his presentation today. You know, Michael Mann, Bill McKibben and Naomi Klein are very concerned about those combination of issues. And I remember former Senator Scott Ludlam giving a presentation in Fremantle talking about information technology and his environmental work, and amongst other things he was kind of talking about the problem of information pollution and how you deal with information pollution. So my talk today really looks at several legal responses to some of these problems in relation to greenwashing, astroturfing, climate denial and information pollution. First of all, I'd like to kind of look at the response of developing certification trademarks, eco-labels. Second, I'd like to look at the response of the trademark system to some of the disputes that have come along. Third, I just would like to briefly mention some of the issues in relation to consumer law. And finally, I would like to talk about some of the efforts to develop larger networks, as it were, in relation to the internet in terms of the .eco project. Now, there have been efforts to develop certification standards in relation to eco-labels, but there have been huge problems in terms of the proliferation of the use of certification trademarks. There are hundreds and hundreds and hundreds of eco-labels. The Eco-Label Index is a kind of an effort by the Big Room Group in Vancouver to try to document all the different kinds and varieties and forms of eco-labels that are there. There are often issues in terms of transparency and accountability and credibility in terms of some of the labels that are there. So it's a very cluttered, crowded market, which makes it very difficult for consumers to determine whether some of the eco-labels are credible and can be relied upon. Historically, there's been a lot of debate over energy labels, and in the United States, the US Energy Star has been very prominent and significant. There's often been issues in terms of the accountability of that regime, so the Government Accountability Office sent in applications to use the Energy Star for things that were not compliant with the standards, for things that didn't even exist, and they got awarded those stars. At the moment, though, there's a huge effort as part of Trump's deconstruction of environmental law and regulation to, amongst other things, cut back on labelling programs like the Energy Star program. So some of the green capitalists that Chris has been talking about are kind of running this rearguard defence action to try to preserve the Energy Star from abolition or defunding under the rule of Trump. I also kind of went off to the European Union and particularly some Scandinavian countries and Norway to have a look at the development of some of the European models in relation to eco-labelling, both the EU eco-label but also the Nordic Swan. I had a nice visit to the office in Oslo of the Nordic Swan office, which they give every newborn baby a kind of a collection of Nordic Swan branded products. In some ways, some of the European standards are much more demanding and much more rigorous, and some of the labelling processes are much more comprehensive in terms of the range of goods and services that are covered. But nonetheless, there remain lots of battles and lots of conflicts over how they've been operating. And also issues in terms of how national schemes like the German Blue Angel scheme works alongside some of the regional schemes that also exist. I went off and visited Vestas, part of the renewable reinvention. Amongst other things, Vestas had a very considerable effort to try to set up its own wind-made label as a special labelling scheme for products and services that had been made through renewable energy. And attracting Danish companies like Lego to have their products branded in terms of a Win-Made label. But as is often the case, there have been real issues in terms of reaching a kind of a critical mass to be a viable, successful labelling scheme. In the United Kingdom, there's been experimentation with carbon footprints, but again there have been challenges as Conservative governments have then limited the funding that they provided for in relation to the Carbon Trust, but there have also been huge issues in terms of the commercial application of the label and to what extent it provides accurate, reliable, credible information. And there's also kind of been the rise of sustainability labels. So there's been an effort to try to develop an upper tier hierarchy of credible, sustainable labels. As Chris talked about before, there's often been huge issues and dangers with the co-option of sustainability, and I think that's a huge challenge at the moment with the development of the United Nations Sustainable Development Goals, and realising those goals with some of the kind of the capture that takes place. The ICL Alliance is an effort to try to set up a series of higher standard labels. And some of them might be kind of quite familiar, as the Fair Trade International label. But I would also note that those labels have their own histories of contestation and debate, and there's been a lot of issues sometimes about whether they've been commercially co-opted and whether they've been deployed effectively. So that's the messy efforts to try to certify green capitalism. I'd now like to kind of have a look at the way in which the trademark system has kind of responded to private branding. And in addition to certification trademarks, there's lots of individual trademarks that have been filed. And having kind of tried to map what's going on through data analytics, it's really a kind of a chaotic space in which all sorts of environmental signifiers are deployed for a wide variety of different trademarks in relation to goods and services. Some of them may be credible, many of them are not. Many of them are quite contested. The United States Patent and Trademark Office has been active in challenging the registration of some of the trademarks on the grounds that they lack distinctiveness. So the key thing for a trademark, it has to have inherent or acquired distinctiveness. There have been quite a few precedents in which the United States Patent and Trademark Office has struck down trademarks on the grounds that they're not distinctive, often related to eco-signifiers. But they've been very reluctant to take action against marks engaged in greenwashing, whether they be by fossil fuel companies or much more contested companies like General Electric with the eco-imagination process. Often there's been also kind of battles in relation to the use of certain pictures associated with the environmental movement. But trademarks can also extend into colours in terms of new science. So one of the very kind of interesting battlegrounds has been BP, who kind of get a very prominent mention in Chris Wright's book. They tried to reinvent themselves as beyond petroleum. And amongst other things, they changed their trademark and their branding and adopted a kind of a Helios sunflower trademark. And in addition to trying to get protection in relation to BP and the new kind of design, they also tried to get trademark protection in relation to the colour green. So you kind of think about greenwashing, there's been some really interesting litigation in Australia and elsewhere in which BP has these abortive efforts to try to get registration in relation to the use of certain shades of green in relation to their goods and services. Hasn't necessarily been successful thus far. It had battles with Woolworths. Interesting, before the High Court of Australia, in those circumstances, they denied that there were any environmental connotations with their mark at all before the very stern Justice Gummo. But I think that's kind of quite interesting in terms of battles over colours being an aspect of the trademark disputes that have broken out. And to my mind, it kind of really raises issues about the limitations of trademark law. I mean, with clauses like the contrary to law prohibition, you should be able to bring an action against a mark to deregister it if it engages in misleading, deceptive conduct. I really do wonder in relation to some of these trademarks whether they should be kind of struck out on those grounds. The other thing that I should also mention is that often well-known trademarks have often been then co-opted by the no logo movement, ad busters, culture jammers, who have used the power of the brand and the mark and the halo of the trademark against big companies. So in other work that I've done, I've been very interested in the clash between the trademark rights, particularly of fossil fuel companies, and the free speech rights of environmental activists and ad busters and culture jammers. And the legal system has found it very difficult to resolve some of those battles between what are the commercial rights of the trademark holders and what are the rights of the community and the public and the civil society in using those. Consumer law has seen more action in relation to greenwashing. It's often been very much dependent upon the political temperament of the day of regulators. So under Democrats, the Federal Trade Commission has taken action under the Green Guides against some companies who have engaged in misleading, deceptive conduct. But under Republicans, there has been very little action. And I'm not holding out my breath that President Donald Trump is going to be encouraging the Federal Trade Commission to take action in relation to misleading, deceptive conduct. When I was in Seattle, I had a chat to a lawyer, Paul Goldman, who was part of an effort to try to use the Green Guides to challenge a so-called certification project, the Sustainable Forestry Initiative, on the grounds that it was misleading and deceptive. It was a forestry-based initiative. And on behalf of forest ethics, he kind of argued that really this was an instance of greenwashing. The ACCC has increasingly become a little bit more active in the space as well, and notably have taken action over Dieselgate against Volkswagen over misleading and deceptive conduct. And there's also a class action being run by Maurice Blackburn over Volkswagen. In the United States, there's been a big settlement of some of the actions by the federal government in the state of California against Volkswagen. But really, I think it also kind of highlights the limitations of consumer law for corporate fraud like this. It seems above and beyond merely greenwashing, although greenwashing certainly was a very important part of what Volkswagen was engaged in terms of its marketing and its advertising. But I think there are some larger issues there as well. And as kind of Chris Wright mentioned, the Exxon new litigation is really a very significant development, particularly with the action by Attorney General of New York Snyderman against Exxon in terms of some of its corporate representations. And in Australia, we've seen some similar developments in terms of the action being brought against the Commonwealth Bank by a shareholder, I think, in terms of climate litigation. So maybe that's a point of expansion, the use of corporate law against corporations in relation to climate change. The Exxon new dispute has become very interesting because Naomi Oreskes and her collaborator have gone through all the documents of Exxon, both their public communications and their private communications, and have highlighted the differences in terms of their internal discussion about climate change and their external denial of climate change. I also talk a little bit about advertising standards are often used to try to take on some of the epiphenomena in relation to greenwashing, particularly in the United Kingdom, against Shell in particular, but also against car companies. Some others have kind of developed community-based efforts to identify greenwashing. So I had a chat to Professor Kim Sheehan in the University of Oregon, who had set up a greenwashing index to try to get people to rate whether or not advertisements had engaged in greenwashing. I also had a chat to a Canadian group, Our Horizon, who, borrowing from graphic health warnings for tobacco products, had pushed for special warnings for fuel bowsers in relation to the climate impacts of fuel, and Berkeley has taken this up in California. To end on a vaguely hopeful note, there have been some efforts to build a new economy and new community spaces and new networks in the space as well. So I went to Vancouver and had a chat to one of the bidders in the new top-level generic domain name process for ICANN. There was a bid by .eco, which is one of the few community bids for the new top-level domain name system. And they had this kind of extraordinary battle against various other commercial bidders to manage this top-level domain name site. But amongst other things, the principals were very concerned about the site being used to promote accurate information about the environment and climate change, being a kind of a site that would enable a wide range of community environmental organisations to come together and benefit from the network and collaboration. But they also said that they would stop greenwashing in various different ways. So Trevor Bowden, Anastasia O'Rourke and Jacob Malthouse are hopeful that .eco will serve that purpose. Unfortunately, it's taken many years. I think I interviewed them first 6 years ago and again a couple of years ago. It's taken them 6 years to win that bid and stave off various other challenges. So I guess my kind of conclusion is that thinking about intellectual property and the environment and climate change, we really need to creatively reimagine how intellectual property deals with some of these problems in relation to greenwashing and astroturfing and climate denial and information pollution. But it will be difficult to deal with government greenwashing, as James Hansen says. A lot of these actions are very commercially focused. Government greenwashing is protected by freedom of speech in certain sorts of ways and various government prerogatives. That will remain an outstanding challenge.